May it please this Honorable Court, this is Counsel 1 appearing on behalf of the petitioners in the case of Hatta Clinic and others versus the Union of India. The Council will be dealing with issue number 1 and 2 before this Honorable Court. The Council seeks permission to address the bench collectively as your Lordships and individually as your Ladyship and your Lordship. Much obliged, your Lordships. If your Lordships are well aware of the facts, the Council seeks permission to begin with the submissions before this Honorable Court. Much obliged, your Lordships. The Council will proceed in a threefold manner, analyzing the constitutionality of the impugned ordinance under each of Articles 14, 19 and 21. The Council most humbly submits that the said ordinance violates Article 14 as it fails the twofold test of intelligible differentia as laid down in the case of Anwar Ali versus the State of Bengal. As there is no presence of rational nexus between the classification done and the objective sought. It is hereby submitted that in the case of Sube Singh versus the State of Haryana, the Honorable Court opined that if the government fails to justify the classification on these two grounds, the said promulgation will be rendered arbitrary. In Menka Gandhi versus the Union of India, it has been clarified that the doubt regarding the arbitrariness when it is said that Article 14 strikes at the arbitrariness in state action and ensures equality of treatment. It is hereby contended that Section 2G of the ordinance, which defines the couples as legally married man and woman, and Section 2R, which defines the term intending couple, go against the very nature of this article. The ordinance is violative of Article 14 as it discriminates between people on the basis of marital status, nationality, and sexual orientation without any apparent rational nexus. The ordinance classifies which woman can be a surrogate mother and which cannot, and excludes homosexual partners as a whole. The Honorable Supreme Court in the case of Baby Manji Yamada versus the Union of India held that the surrogacy arrangements can be made for same-sex couples. The Council would most humbly submit before this Honorable Court the 228th Law Commission report, which says that even a single or a gay parent can be allowed to have a child through surrogacy. It is contended that the ordinance, by establishing a eligibility criterion, puts a blanket ban on certain groups of people who are within their rights to seek surrogacy. The Council would most humbly submit before this Honorable Court that the ordinance violates Article 21 of the Constitution of Nilfgaard, as it puts a blanket ban on the right to reproductive autonomy of a certain group of people without a just and reasonable nexus between the objective sought and the act done. The Council most humbly submits that according to the Universal Declaration of Human Rights, men and women of all age, without a limit, inherently possess a right to procreation and a right to reproduction. It was held in Nalsa versus the Union of India that the non-recognition of gender identity is a grave violation of Articles 14 and 21. The said ordinance places a blanket ban on homosexual surrogacy when it defines the term couple in Section 2 Part G of the said ordinance. Hence, it is violative of Article 21 as there seems to be no reasonableness in this restriction. Your Lordship, we are challenging the whole constitutionality of the ordinance itself. Much obliged, Your Lordships. In BK Parth Sarthi versus the Government of Andhra Pradesh, the Honorable Court has agreed with the decision of US Supreme Court in Jack T. Skinner versus the State of Oklahoma, in which the right to reproduction was characterized as one of the basic civil rights and thus has been enshrined under Article 21 of the Union of Nilfgaard. It is hereby contended that the ordinance, by putting a blanket ban on live-in couples, single individuals, and persons from the homosexual community, violates their right to reproductive freedom without any reasonable nexus. The Council most humbly submits that the said ordinance is violative of Article 19(1)(g), in essence, that it puts a restriction on the ability to practice any profession and carry out any occupation without any reasonable nexus to the objective of curbing the exploitation of women. It is contended that altogether banning a profession, that of being a surrogate mother for monetary compensation, is an extreme step and has no reasonable nexus with the objective of protecting the said woman from exploitation. But The ordinance goes on to strip such women of their livelihood, which violates their right enshrined under Article 19(1)(g). In the case of Lakshmi Khansari versus the state of UP 1981, the Honorable Court has laid down in paragraphs 880 and paragraphs 881 that if the restrictions imposed under Article 19 Part 6 are in consonance with the directive principles of state policy, then they shall be upheld. But in the present case, the petitioners would like to contend that the said ordinance goes against the Article 41 of the directive principles, which is the right to work, and hence is against public policy. It is thus contended that as laid down in the cases of Modern Dental College versus the state of MP and Muhammad Farooq versus the state of MP, that if an alternative existed, then the restriction under Article 19 Part 6 shall not be held reasonable. It is humbly contended before this Honorable Court that the government, instead of putting regulations to protect women from being exploited, such as verification of intending parents, the government opted for a complete blanket ban on commercial surrogacy, which is unreasonable and hence ultra-vires the constitution of NILFCAT. If it may please the court, the council seeks permission to proceed with issue number 2. Yes, your lordships.
The proposition that you have tried to propound by placing reliance on Article 41 of the Constitution, which deals with the directive principles.
Yes, your lordships.
Just try to reconcile how it is. It can be made applicable in this case.
Yes, your lordships. I will reconcile that for you.
Please. Article 41 says right to work, to education, and to public assistance in certain cases.
Yes, your
and
lordships.
it is not enforceable by the provisions of law. It is not enforceable, right?
Yes, your lordships. It is not enforceable, but as laid down in the case of Lakshmi Khansari by the Honorable Court, if I will reiterate for your lordships, in the case of Lakshmi Khansari versus the state of UP, the Honorable Court laid down that if the restrictions imposed under Article 19 Part 6 are in consonance with the directive principles, then they shall be upheld. Whereas the petitioners are contending that the restrictions imposed in this case are not in consonance with the directive principles and hence should be held unreasonable.
Okay. You may proceed.
Much obliged, your lordships. The council shall begin with the submissions of issue number 2. Much obliged, your lordships. It is most humbly submitted before this Honorable Court that the writ of habeas corpus thus filed is maintainable and that the custody of the child with the surrogate mother is illegal in nature. The council shall read paragraph number 50 of the said ordinance in question. Paragraph 50 of the said ordinance says, subject to the provisions of this act, there shall be provided a gestation period of 10 months from the date of coming into force of this act to the existing surrogate mothers to protect their well-being. It is contended that as given in the fact sheet, part 5 of the fact sheet, the ordinance came into effect during the gestation period of Mrs. Sagarika, that is 2 to 3 weeks prior to the expected date of delivery. So the petitioners are contending that this falls under the 10-month gestation period provided under the said article, and hence the ordinance is not applicable to the said case, and hence the writ of habeas corpus is enforceable before the Honorable Court. The council shall most humbly submit before this Honorable Court that as laid down in Nilanjan Bhattacharya versus the state of Karnataka in 2020, the Apex Court held that the most important contention while issuing a writ for custody of a minor is the minor's well-being. It is most humbly submitted to this court that in the present case, the well-being of the minor is with the intending parents because the surrogate mother is illiterate and is not financially suitable to take care of the said child. Yes, your lordship.
Is the surrogate mother not a natural guardian? Can she not take care of the child? What you are submitting is that the writ which is filed, this is just a query to you.
Yes, your lordship.
Whether the couple is more capable of well-being of the child.
Yes, your lordship, that is what we are contending.
Yes.
Here.
So my query is that the mother who has given the birth, surrogate,
yes, your lordship.
she is a natural guardian. of that child?
Your Lordship, the petitioner would like to contend that as given in the guidelines for ART clinics by ICMR, which is a government institution, the guidelines have been provided that even if first I would like to clarify on the point raised by your ladyship.
No, I will just rephrase my question to you.
Yes, Your Lord.
This is a writ of habeas corpus.
Yes, Your Lordship.
So a habeas corpus writ would lie
Yes, Your Lordship.
when the corpus is in illegal custody, illegal detention.
Yes, Your Lordship.
So can we say that the corpus is under illegal detention or illegal custody when the mother is a natural guardian,
Yes, Your
surrogate
Lordship.
mother?
Yes, Your Lordship.
That is what my query is.
Much obliged, Your Lordships. As mentioned in our written memorial, guidelines for ART clinics by ICMR in point number 3.10.1, 3.16.1 and 3.5.4, it clearly states that the surrogate mother shall not be the legal mother and the birth certificate shall be in the name of the genetic parents. Hence, as per the above guidelines, it is contended that the legal guardians of the said child born out of surrogacy will be the intending parents and not the surrogate mother. Much obliged, Your Lordship. It is also hereby contended that the secondary recourse of arbitration, as has been said, that it is applicable in the present case. The petitioners contend that it is not applicable as laid down in the case of Booz Allen and Hamilton versus SBI Home Finance Limited, which states that certain forms of disputes are non-arbitrable in nature. The para number 21 of the said judgment clearly states that the matters of child custody shall be rendered non-arbitrable. The council shall reinforce the said argument by quoting that the non-arbitrability of child custody matters is reinforced by the Vidya Drolia versus the Durga Trading Corporation case, in which a fourfold test of arbitrability has been laid down by the Honorable Court, and the petitioners contend that the said case does not pass the said fourfold test. It is most humbly contended that the mere presence of an alternative remedy does not bar the petitioner from invoking the said writ of habeas corpus, as laid down in the case of Radha Krishna Industries, that the presence of an alternative remedy does not divest the High Court of its power under Article 226 of the Constitution of Nilfgaard. It is hereby most humbly contended before this Honorable Court that the detention of the child by the surrogate mother as born out of surrogacy is illegal, as the petitioner has already laid down before the Honorable Court. It is also in furtherance of that very argument, the petitioner would like to contend that it has been laid down in the case of Tejaswani Gaud versus Shekhar Jagdish Prasad Tiwari. The writ of habeas corpus can be issued when there is a question of illegal detention of a minor, and hence the petitioner would like to submit before this court that the said detention by the surrogate mother is illegal in nature, because in the present, because one reason has been already provided by the petitioner. To reinforce the said point, both the gametes out of which the child was born were of the intending parents, and this is a case of gestational surrogacy and not of a traditional surrogacy, and hence the legal guardians of the surrogate child are the intending parents and not the surrogate mother. The council would like to conclude the submissions of issue number 1 and 2. Much obliged, Lordships. The council will call upon council 2 to deal with issue 3. Much obliged, Lordship.
Much obliged, Your Lordships. May it please the Honorable Court, I am the second counsel appearing on behalf of the petitioners in the case of Hatter Clinic and others versus the Union of Nilfgaard. For the next 10 minutes, I would be trying to assist the Honorable Bench with petitioner's side of the third issue. The co-counsel shall be presenting his arguments on the submission that Surrogacy Regulation Ordinance 2019 is exclusionary in nature. For the sake of convenience, this particular issue is being dealt in two limbs. If there are no preliminary questions of Your Lordships, the Council may proceed with the first submission. Much obliged, Your Lordships. Your Lordships, the Council contends that the ordinance violates Article 15, Clause 1 of the Constitution of Nilfgaard. If Your Lordships may allow me to quote the exact definition. The state shall not discriminate against any citizen on ground only on religion, race, caste, sex, place of birth, or any of them. Your Lordships may refer to para 60 of the memorial. It is an established law in the case of NAS Foundation versus Government of NCT Delhi 2009 that the term sex in Article 15 includes sexual orientation in it. It will be discriminative and violative of Article 15 against homosexual couples if the legislation and personal laws prohibit them based on their sexual orientation. Furthermore, in the case of Navtej Singh Johar versus Union of India 2018, the Honorable Supreme Court moved from the narrow view and held that any ground of discrimination, whether direct or indirect, as in the case of this ordinance, which is founded on a particular understanding of the role of sex, constitutes discrimination under Article 15. This way, the Supreme Court expanded the prohibition on ground of discrimination. Your Lordships, the Council humbly submits that the inclusion of the word marriage in the section 4C2 of the ordinance, of the said ordinance, exploits the lacunae in the jurisprudence, as there is no law still that legally sanctions the same-sex marriages in the constitution of Nilfgaard. Hence, the ordinance is dealing with a subject on which the existing legislature is silent. Gay couples like Mr. Rajiv and Mr. Rhythm, as mentioned in the facts of the case, even if they want to have a surrogate child, they cannot have it since they are not under the ambit of section 4C2 and cannot register marriage, which is one of the requisites to take the benefit of the said ordinance. Thus, to summarize, Your Lordships, the Council humbly submits that when a particular statute seeks to differentiate among individuals based on grounds of this article to adjudicate the validity of the legislation, a distinction has to be drawn between the object underlying of the impunged act, and the act may be good and the manner adopted therein, but the object underlying the act, but its validity has to be judged by the method of its operation and effect on the fundamental rights involved. Thus it is contended that sexual orientation on grounds analogous to sex mentioned under section 15 clause 1 of the Constitution and discrimination based on sexual orientation is not permitted under the same. If Your Lordships have no preliminary questions, the Council would like to proceed with the second limb of the issue.
See, this is something other than what you are arguing. It's common knowledge, like a child would need a father and a mother. The role of both are different.
Yes, Your Lordship.
Mother is a nurturer, father is a provider. So, allowing same-sex couple to have a child, my question is that is it beneficial to the child? And like you are arguing, if I am not mistaken, if you are arguing that this ordinance should not be applicable to the same sex.
Your Ladyship, I am arguing that the section 14C2 by including the word marriage, when the existing legislature is silent on one aspect of same-sex marriage, and thereby it automatically excludes a class of people from taking the benefit of this ordinance, and hence this is exclusionary in nature.
So, if the same-sex marriage, it excludes, and if they are given the advantage of this, will they be a proper couple? Rather, this marriage would be to take care of a child, infant.
Indeed, Your Lordship.
So you are arguing for the rights of the surrogate mother, or whether the couple who is going to take the custody. But we are on the ground that fact that whether the child would have any benefits if it's given to the same-sex marriage.
Indeed, Your Lordships, I would be answering to your queries. The Council would like to say that the jurisprudence of the right to marry under Article 21 is given, and hence we cannot discriminate on the basis of one of our citizens' right to marry. Other than that, on the taking care of the child, if we discriminate based on if a male or female can provide a child for a better for better or worse, we are violating the constitution itself, Article 14, that we are not equating male and female. Much obliged, your lordships. If your lordships have no preliminary questions, the council would like to proceed with the second limb of the issue. Your lordships, the council submits that when section 4C2 is read with the current interpretation of the sections in Hindu Marriage Act and Special Marriage Act, in which the status of same-sex marriage is not explicitly recognized, it becomes exclusionary in nature. By mandating marriage under section 4C2 of the ordinance and not recognizing same-sex marriage at the same time, the ordinance is violating right to marriage for people belonging to the LGBT community under Article 21. In Menaka Gandhi versus Union of India, 7-judge Constitutional Bench, 1978, the outcome was that law limiting rights of personal liberty would not only have to be procedurally correct, but also substantively valid for it to be a law. The present jurisprudential status of same-sex marriage deprived people from belonging to the LGBT community of their fundamental right to marry enshrined to them under Article 21.
So far as Menka Gandhi case is concerned, the law has to be applied on the facts of the case. It was in 1977-78.
Indeed, Your
Now
Lordship.
we are in 2022. Law is obviously always evolving, but at the same time, how do you reconcile with the fact of Menka Gandhi with this? How can the ratio laid down in Menka Gandhi case can be made applicable in this case?
Your Lordships,
Reason being that there is a social taboo applied to the this same-sex marriage or LGBTQ, whatever the relationships are there. So how do you reconcile with that proposition? And how can you apply the law laid down by the Honorable Supreme Court in case of Menka Gandhi?
Your Lordships, it was a substantive judgment, and
I do understand it was a substantive judgment, but it has to be applied in the facts of the case.
Your Lordships, in Menka Gandhi, the due process of law was...
Apparently, it is too ambitious and proposition, but at the same time, how do you reconcile with the facts of this case?
Your Lordships, as we know that the personal laws in existing legislature are not explicitly recognizing the same-sex marriage, that's why in Menka Gandhi, the bounds of the due process of law was examined. And in that context, the council is presenting Menka Gandhi. Much obliged, Your Lordships. Your Lordships, in the Shafin Jahan case, I would like to quote Justice Deepak Mishra that the societal values and morals have their space, but they are not above the constitutionally guaranteed freedom. Your Lordships, due to the paucity of time, if I may be allowed to recite the prayer. Much obliged, Your Lordships. Wherefore, in the lights of the given facts stated and arguments advanced and authorities cited, it is most humbly prayed before the Honorable Supreme Court of Nilfgaard that it may be graciously pleased to adjudge and declare that the provisions of the Surrogacy Regulation Ordinance 2019 ultra-vires the Constitution of Nilfgaard and hence should be struck down. That the provisions of the Surrogacy Regulation Ordinance 2019 are exclusionary in nature, which violates the basic principle of the said Constitution and hence non-maintainable. That the writ petition of habeas corpus humbly submitted before the Honorable Supreme Court of Kimanu is maintainable and hence furnish the rights of the child back to the intending parents, and or pass any other order or direction that it may deem fit in the best interest of justice, fairness, equality, and good conscience, all of which is most humbly prayed. For this act of kindness, the petitioners are duly bound and shall ever pray. It was an honor argument before the bench. Much obliged, Your Lordships.
council seeks permission to proceed, Your Lordships. The council seeks permission to proceed, Your Lordships. Greetings to the bench. The counsel for the respondents is standing before the Honorable Court in the case of Hatter Clinic versus State of Haryana, Mr. Atulya and Mrs. Anna versus State of Haryana, Mr. Rajiv and Mr. Rhythm versus State of Tarakota, and Mr. Suhas and Mrs. Suhasini versus State of Kimanu. If Your Lordships are well versed with the facts of the case, the council seeks permission to proceed. The counsel for the respondents shall be dealing with 3 issues today before the honorable bench. The first issue is that whether the conditions laid down for the eligibility certificate of surrogacy under section 4(3)(c) of the ordinance are constitutional. Secondly, whether a blanket ban on commercial surrogacy violates article 19(1)(g). And thirdly, whether the writ petition of habeas corpus present before the honorable court today is maintainable and the custody of the child should be given to the intending parents. If Your Lordships have no preliminary questions, the council seeks permission to proceed with the first issue. Your Lordships, the first issue before the honorable bench today is that whether the conditions laid down for eligibility certificate of surrogacy in section 4(3)(c) of the ordinance is constitutional. The council most humbly submits before the honorable court that the provisions of section 4(3)(c) and 4(3)(b) are constitutional in nature, and the council will be basing its argument on 3 premises. Firstly, that the conditions provided in the ordinance are not violative of article 14. Secondly, that the conditions provided in the ordinance are not violative of article 21. And thirdly, that the requirement of marriage provided in section 4(3)(c)(2) of the ordinance, as well as the definition of couple in section 2(g) of the ordinance is constitutional in nature. The council seeks permission to proceed, Your Lordships. Starting the first premise, the council most humbly submits before the honorable bench that the conditions provided in the ordinance for the eligibility certificate that has to be obtained from the district medical board by the intending couple are not violative of article 14 of the constitution, because the classification done in this particular legislation is reasonable and non-arbitrary. The council would submit its arguments on the basis of the twin test laid down in State of West Bengal versus Anwar Ali Sarkar case, in which the apex court held that for a classification to be reasonable, the classification has to satisfy 2 main criterions. The first one being that the classification should have an intelligible differentia on which the classification is done. And secondly, that the intelligible differentia in the classification should have a rational nexus with the objectives that are sought to be achieved through the legislation. Your Lordships, the council would submit before the honorable bench that in the given case, in the given legislation, the conditions provided in section 4(3)(c) and 4(3)(b) have an intelligible differentia of classification, which is as follows: that in section 4(3)(c)(1) of the ordinance, Your Lordships, it is given that the age of the intending parents, is a criteria for eligibility to have an eligibility certificate for surrogacy. It is given that the age of the intending father has to be between the ages of 26 years and 55 years, and the age of the intending mother has to be between 23 years and 50 years. The condition is given that when parents are allowed to go through the procedure of surrogacy, they should show that they are legally, physically, mentally, and financially capable of catering to the biological, social, and financial needs of the child that is born through surrogacy, and thus these conditions are necessary for parents to satisfy before they apply for the procedure of surrogacy and have a child through the procedure of surrogacy, Your Lordships. Moving on, the second.
So far as the age criteria is concerned,
Your Lordship,
of a lady or a man, that is, cap is given at, for the lady it would be 50, and for male it would be 55.
Your Lordships.
Where is the rationale for, and how do you, justify that capping the, age criteria at 50 or 55? Reason is, there are cases, reported judgments also, to the effect that, after the death of the male child or the only child, the Supreme Court has even permitted the surrogacy also. But in that case, if somebody, a lady's son dies at the age of, and at that time she is around 55,
Your Lordships.
and she would like to go for, another child, and because of certain, medical reasons, because of some, surgical procedure, she is unable to, reproduce. Then in that case, she may, go for surrogacy also. Then how do you justify, the age criteria at the age of 50 or 55 respectively?
Your Lordships, in the female biological cycle, there's a concept of menopause, and after a certain age, a female is anyways not able to reproduce through natural means.
That is why. What is the justification for this?
Your Lordships, in the ordinance, it is provided that the gametes cannot be taken from the surrogate mother. So if Your Lordships.
From the surrogate mother, but what about the father?
Your Lordships.
What about the father?
Your Lordships, I would like to draw the attention of Your Lordships to flag number 2 of the compendium that has been provided. Your Lordships. Your Lordships, in point 2.2 and point 3.8, as well as in flag number 1, which is the United Nations Convention for the Rights of the Child, which has been held as binding on the legislature in the case of Salil Bali versus Union of India. It states in the point 3.4 in the article 3rd of the convention, it has been given that the state is duty bound to act in the best interest of child, Your Lordships. Considering the best interest of the child, Your Lordships, the legislature had to draw a line where the parents are deemed to be, where the parents, there has to be a classification of who shall be allowed to go for the procedure of surrogacy and have a child. If anyone and everyone is allowed to have a procedure of the child, Your Lordships, this is a reasonable restriction, and if anyone and everyone is allowed to have a child through a procedure of surrogacy, that will not be in the best interest of child, Your Lordships. Your Lordships. The council would like to move on to the next submission, which is that the condition on citizenship provided in section 4.3c3 of the ordinance is reasonable. It is submitted before the honorable court that there have been incidents as mentioned in the 102nd report of the Parliamentary Standing Committee of Health and Family Welfare, which has been given in the compendium in flag 4, Your Lordships. In flag 4, there are incidents mentioned where couples from foreign jurisdictions have came to our country and have engaged a surrogate mother and then have abandoned the child. And also there are cases like the case of PM versus CM given in flag 5 of the Constitution, where the surrogate mother has refused to. Your Lordship.
Intending parents have left the child.
Your Lordship.
Which case you are referring to? Like number 4 that you said.
Your Lordships.
Any such instance,
Your Lordships, the council would like to draw the kind attention of Your Lordships to point 5 of the annexure given in 102nd report.
No, yes, exactly. The
Your Lordships.
court case is surrogacy in India. That is what flag number 4, second page says. And out of
Your Lordships, flag number 2.
You have given number of instances in all 7 in nature, total 7. In which case the parents, the biological parents have left the child?
In point number 2 and point number 5, Your Lordships. Point number 2 is about a couple from Germany, and point number 5 is about a couple from Australia, Your Lordships. Your Lordships. Your Lordships, it is most humbly submitted before the Honorable Court that in cases where parents from foreign jurisdiction are allowed to have a child through surrogacy in India, there can be disputes on citizenship, and when a child's citizenship is not clear, it can hamper its future development, and a citizenship is a very important criteria when the child wishes to go for higher education, which the state is duly bound to provide, Your Lordships, which the state is legally bound to provide. If Your Lordship can refer to flag number 1, Your Lordships. Flag number 1 in Article 26 and 28 of the United Nations Convention on the Rights of the Child, it is provided that under Article 26, state parties shall ensure that all the child has the right to benefit from social security, and Article 21 states that every state shall ensure, every state which is a party to the convention shall ensure that the child gets accessibility in all ways possible to higher education and secondary education, Your Lordships. If Your Lordships are satisfied with the submission, the Council seeks permission to proceed, Your Lordships.
Please, please.
The next submission is that the conditions provided in section 4.3c of the ordinance have a reasonable nexus with the objectives that are sought to be achieved through the legislation. In Union of India versus M.V. Valiappan case, it has been held that there shall be reasonable nexus, and the classification shall be based on the qualities and characteristics of the objective. Your Lordships, it has, as has been earlier laid down by the Council, the state is duly bound to provide the state is duly bound to act in the best interest of the child under National Policy for Children 2013, and thus when the state restricts anyone and everyone from going through the procedure of surrogacy and regulates who can be a parent through the procedure of surrogacy rationally, then this is a reasonable classification under Article 14. Your Lordships, the Council seeks permission to proceed to the next issue. Your Lordships, the Council most humbly submits before the Honorable Court that the impugned legislation is not violative of Article 21 of the Constitution, Your Lordships. The Council humbly submits that in the case of ADM Jabalpur versus Shivkant Shukla, it was held that liberty is a regulated freedom which can be confined and controlled by law. Your Lordships, as has been earlier established by the child, the state is duly bound to act in the best interest of the child that is born through surrogacy, and thus the state has to ensure that there are regulations on who can get a child through the procedure of surrogacy. Your Lordships, in the case of Tulsa versus Durghatia, it was held that even in the case when a child is born out of wedlock, the duration of the relationship has to be considered in order to give the custody of the child to the parents. Therefore, it has been held by the court. It has been held by the court that the duration of relationship has to be considered before giving it, before someone is allowed to have a child through the procedure of surrogacy. Your Lordships, Section 3(4) of Juvenile Justice Act 2015 mandates that all agencies should base their decisions in respect of a child, on the primary consideration that they are in the best interest of the child and to help the child to develop to full potential, Your Lordships. Your Lordships, it is further contended that the condition provided in section 4.3c(4) of the ordinance, which states that there should be no surviving child of the intending parents, is based on the rationale that surrogacy should not become the natural method of parenthood, Your Lordships. This condition has been provided in order to protect the natural order of the Indian society, and in order to ensure that surrogacy does not become the natural way of having children, and surrogacy should be resorted to as a last resort in case the parents are not able to conceive in a natural way, Your Lordships.
You rightly said that it should not be resorted to as a natural way, but at the same time, again you said that natural resource, right? There are cases and cases where there is a surviving child, but is suffering from autism or something, some other, infirmity or some genetic defect. There is definitely there is a, surviving child. But at the same time, if the parents are inclined to go for, and they would not like to take any risk with the, requirement of this genetic defect.
It has been the exceptions are provided to section 4.3c(4) in the ordinance, Your Lordships. All the conditions mentioned by you are catered for in the ordinance, Your Lordships. If a parents have a child that is suffering from a terminal disease or a disease which has no permanent cure, then the parents can go through the procedure of surrogacy even if they don't qualify, Your Lordships. The Council seeks an extension of 2 minutes for the last submission, Your Lordships.
Please.
Your Lordships, the last submission of the Council for the respondent shall be that the provisions of the ordinance are reasonable and not exclusionary in nature. The first premise of the argument is that the Council for the petitioners have talked about Article 15 and how it prohibits discrimination on the ground of gender. But in the judgment of Air India versus Nargesh Mirza, it has been held that Article 15 and 16 prohibit discrimination only on the ground of sex alone and not on the ground of sex coupled with other circumstances. This view of the Apex Court was approved further in the case of Yusuf Abdul Aziz versus State of Bombay, Your Lordships. Here, the state has not discrimination on the ground of gender only. The state has acted in the best interest of the child, your lordships. The other conditions mentioned in the ordinance are essential, as has been established by the council for the respondents, to ensure the best interest of child principle, which has been mentioned in section 3(4) of Juvenile Justice Act 2015, your lordships. Further, the council would like to submit that on the point that exclusion of LGBTQIA community people is present in the ordinance, the council would like to seek the kind attention of your lordships to flag 6 of the compendium that has been provided. There is a research on new family structures which had 15,000 respondents with a significant number of children who had parents from the LGBTQ community. It was found in the research which has been done by the University of Austin in Texas by a reputed expert of same-sex relationships who has conducted many research in this field. It was held that, your lordships, the last submission. Your lordships, it was held that when children who had parents in same-sex relationships, they fared worse on 24 of the 40 matrices of social and educational criteria, your lordships. If your lordships are satisfied with the submissions of the council seeks permission to invite his co-counsel to present the further.
Please.
It was an honor arguing before your bench, your lordships.
Please.
Greetings to the bench. Proceeding with the submissions, the council will be dealing with issue 2 and issue 3. If it may please the bench, the council humbly seeks the permission to move further with the submissions. Much obliged, your lordships. Your lordships, the second issue is whether a blanket ban on commercial surrogacy violates Article 19(1)(g) of the Constitution of Nilfgaard. The council humbly submits that the promulgated ordinance does not violate Article 19(1)(g) of surrogacy clinic as well as that of surrogates. Given in Section 6 of Article 19 of the Constitution, the fundamental right to practice any profession or carry out any trade or business is not an absolute right and can be subjected to reasonable restrictions. No freedom conferred upon by the Constitution is absolute in nature, and reasonable restriction can be imposed by the state under Clause 6 of Section 19 in the interest of general public. In the case of Narendra Kumar and others versus Union of India and others, the Supreme Court clearly held the view that the term restriction in Article 19(1)(g) and 19(6) of the Constitution can be inclusive of the term prohibition on a profession. The ordinance does not completely bar surrogacy, it just bars commercial surrogacy and has promulgated regulations for altruistic surrogacy in interest of the general public, which has been specified in Section 4, Clause 2 and Section 4, Clause 3 of the ordinance on flag 8 of the compendium. The conditions have been laid out separately for the clinics and the surrogate who wish to practice this profession separately in order to attain better services even for intending parents and avoid any disputes arising out of the same matter. Additionally, a fourfold test that was adopted in the case of Om Kumar versus Union of India, the principle of proportionality was laid down and adopted by Indian courts, which assesses any ordinance or law imposed on two grounds. That is, first, the limitation imposed should have a legitimate aim and should strike a balance. Secondly, the rational nexus should be there behind any law passed or ordinance passed. And thirdly, there should be the necessity to pass that ordinance or law. And fourthly, the balance between restrictions and freedom granted should be stricken by the law. It should not be arbitrary, but it should also see that it is relating to the subject matter that is to be catered to. In present case, the restriction on commercial surrogacy is imposed for the proper purpose. That was to save the surrogates which were employed in this profession from exploitation, as has been mentioned in part 1 of the Moot Court proposition, wherein it is given that 51% of surrogates were being exploited on the basis of the socio-economic backgrounds. Also, in this case, the nexus of behind passing this law was that to stop the clinics from exploiting it, as well as to stop the issues that were arising out of the kids being born through surrogacy. Therefore, the ordinance completely is in line with the nexus to achieve that purpose. Thirdly, it was the necessity as has been specified in the Moot Court proposition, as there was opposition and pressure from public groups as well as associations working for welfare of the general public. It has been mentioned in part 1, your lordships, that there was pressure from the other groups to pass an ordinance which regulated this and to impose a complete ban on practice of surrogacy. The government banned the practice of commercial surrogacy, but to let there be a resort for the infertile parents to conceive. The government just regulated altruistic surrogacy. Further, in Municipal Corporation of City of Ahmedabad and others versus Jan Muhammad Usman Bhai and others, the apex court held that if a law requires that an act which inherently is dangerous or noxious or injurious to public interest, health or safety, or is likely to prove a nuisance to the community shall be done under a permit or a license of an executive authority. It is not per se unreasonable, and no person may claim a license for a permit to do the same as per the right. The ordinance has mandated certain eligibility criteria for surrogacy clinics to obtain legal valid license to operate under the executive authority specified by the ordinance. This provision aims to ensure that only the surrogacy clinics that are well equipped to follow the procedure and let the parents have the child through the procedure of surrogacy are able to practice this profession in a standardized manpower and infrastructure and allow the intending parents to have the best of these services. Furthermore, as clarified by the matrix of the fact that 51% of the surrogate's mother were not being adequately remunerated for the same, to regulate this and help them to have an equal standing, to be not a disadvantaged party in the bargain, Section 6 of the ordinance clearly specifies that the written consent of the surrogate is mandated, which therefore also includes that all the conditions and after effect of the contract which she is entering into has to be communicated to her properly in order so that she knows what she is entering into. Therefore, she is not exploited in the terms that the contract doesn't specify the condition for which she is agreeing to. It is therefore established that the ordinance was promulgated in the best interest of the public at large. It is to regulate the standards for the clinics and ensure better services for the intending parents, keeping in mind to safeguard the interests of the surrogates as well as surrogacy clinics. It is therefore humbly submitted before the Honorable Court. The restriction imposed by the ordinance are not unproportional in nature and are not arbitrary or unreasonable in nature. The ordinance promulgated is in the best interest of public, including clinics and surrogates, and the ordinance therefore does not violate Article 19(1)(g) of the Constitution of Nilfgaard. If your lordships are content with the arguments, the council humbly seeks permission to move further with the next issue. Much obliged, your lordships. Your lordships, the third issue is whether the writ petition of habeas corpus is maintainable by the intending parents, and the intending parents shall get the custody of the child born through the surrogacy contract which they entered into or not. The council will support its argument on 3 premises. Firstly, the subject matter of surrogacy is arbitrable due to having a valid arbitration clause specified in the contract. Secondly, the judicial intervention in present case should be limited and restrictive in nature. And thirdly, the surrogate should be allowed to keep the child and the custody of the child shall not go to the petitioner. Proceeding with the first argument, in the case of Booz Allen and Hamilton Incorporation versus SBI Home Finance Limited and others, the judges may refer to page 29, para 56 of the memorial on behalf of respondents. It is clearly stated that Supreme Court defined...
Just a minute.
Yes, sir.
Here you say that the petitioner, that is the couple, they do not have a locus standi. How do you explain that? Since there was an agreement between the surrogate mother and the petitioner, intending parents, couple. So, how do you explain that they don't have a locus standi?
Your Lordship, the Council was about to deal with it in the further issues. Coming to the first submission, continuing, that the Supreme Court held that it was the matters involving questions to right in personam, that was the rights against specific parties as in case of contracts. The subject matter will consider to be arbitrable, clearly held by the Supreme Court. It is well established by the fact that surrogacy contract which was formed between the parties contained an inclusive arbitration clause which clearly stated, the judges may refer to part flag 9 of the companion provided, part 5 para 13 of the Moot proposition, wherein it is clearly stated that disputes arising out of surrogacy contract shall be settled by the sole arbitral tribunal of Mr. Raman and as per the Arbitration Conciliation Act of 1996. Therefore, the arbitration clause specified in the surrogacy contract is inclusive and valid, which was signed by both the parties. Your Lordships, that was a part of second submission the Council is going to deal with in the second submission. May the Council continue?
And the arbitration in this case, would it not amount to in-house arbitration, which is held to be bad by the Honorable Supreme Court in recent judgments?
Your Lordship, as it has been agreed upon already.
The proposed arbitrator is brother of that lady. In this case, going by that, would it not amount to in-house arbitration?
Your Lordship, the arbitrator is not the brother of the lady, though the Council acknowledges the fact that yes, the arbitrator is in relation to the petitioner. However, it may lead to biasness.
Biasness, conflict of interest, etc.
The arbitration clause clearly, the Arbitration Conciliation Act has provisions provided in case where there is in-house arbitration, in case of changing of the composition of the arbitral tribunal, that can also be resorted to in this matter. Additionally, coming to the question of the locus standi, having a locus standi is a condition precedent for an exercise of power under the jurisdiction of the court. Hereby, the defendants are contesting that the present case does not lie under the jurisdiction of the present court. Therefore, the petitioner do not have the locus standi to stand before the court under the writ petition. It is not. The petitioners have the locus standi to resort to arbitral tribunal. There they do hold a locus standi. But to stand before the court in the matter of habeas corpus writ, which the Council shall be contending in further arguments. Proceeding to the second submission, in the case of Grid Corporation.
You mean to say because of the arbitration clause, this writ is not maintainable?
In the present case. In the case of Grid Corporation of Orissa Limited versus Balasore Technical School, the Honorable Supreme Court held that if dispute is within the scope of arbitration and has a clarified arbitral clause, it is in no part of the province of the court to enter into the merits of the case. In case a right in rem would have been exploited, the court would have had the jurisdiction under the said writ. But here the right violated is right in personam. That is, the right violated is against a particular party. The violated right is a dispute is because the arising out of the dispute relating to contract. Therefore, the scope of jurisdiction under Article 32 and 139A, under which the writ has been transferred, does not hold. Moving further, the petitioner 4 would like to contend that in Section 10 of Contract Act 1872, it is specified that while entering into a contract, there shall be consensus ad idem. That is, both the parties shall be agreeing to the conditions of the contract in same manner. Referring to Part 5, Para 12 of the Moot proposition, it is clearly stated that the surrogate was uneducated, and it is nowhere clarified that she was completely explained the conditions of the contract she was adding into. Therefore, it is very well the consent of the surrogates can. The Council humbly seeks extension of 2 minutes. Thank you, Your Lordships. Therefore, the Council is contending that the consent of the surrogate can also be questioned on Section 16 of the Contract Act 1872, Flag 7 of the Compendium, wherein it defines undue influence, wherein it has stated that if a party is in a clear relationship where they can dominate the consent of other party, as it is clearly established by the fact that Mr. Raman had an employer-employee relationship with the husband of the surrogates. So there is a clear fact that the consent of the surrogate can be well manipulated while entering into the contract. Also, in Central Inland Water Transportation Corporation Limited versus Brojonath Ganguly, the court clearly stated that a contract which was entered between parties who are not at the same footing in the bargain power will not be enforced by the court. Therefore, it is humbly submitted before the Honorable Court that according to the matrix of the fact, the surrogate was clearly the disadvantaged party. Therefore, the contention should be taken into regard as to the consent of the surrogate was free or not, and the custody should not directly be transferred to the petitioners. If your lordships are content with the arguments, the council seeks permission to proceed with the prayer. Much obliged, your lordships. Wherefore, in the light of facts presented, issues raised, arguments advanced, and authorities cited, the council, on behalf of defendant, humbly pray before this honorable court that it may be pleased to adjudge and declare that the blanket ban on commercial surrogacy is not violative of fundamental rights as enshrined in the Constitution of Nilfgaard. Therefore, the ordinance is constitutionally valid. The provisions of Section 43C of the Surrogacy Arrangement Ordinance 2019 are valid, and the surrogacy as an arbitrable subject, therefore the arbitration clause in the contract shall be held valid, and the writ petition shall not be held maintainable, and the custody of the child born through such contract should not go to petitioner 4, or pass any other order that the court may deem fit in the light of equity, justice, and good conscience. And for this act of kindness, your lordships, the respondent shall as duty bound ever pray. Thank you, your lordships. It was an honor arguing before the bench.
By the way, both the teams have really done well. Yes. Both the teams, we can see that, bubbling with lot of energy.
We have shortage of time. But both the teams have really fled well beyond the expectations. And it's really, it's tough for us to...
Who would be out for perform which team? It is difficult to judge. But anyway, both of you done well.
Yes.
Yeah.
Very well prepared and very thorough. And I must say that the queries put by all the three of us have been very adequately answered ex tempo. So, good job.